statement which you will present as part of your evidence before this commission. May I ask you to start reading your statement from paragraph 1?
Just a question. Just a quick one. Ms. Matebo, it's going to be a long journey today. It's a long statement. So please feel free to drink water. It's going to be a long, long journey. And I'm sure we'll traverse it well. All right. All right. Yeah, someone else now. All right, thanks.
Thank you, Advocate.
Paragraph 1.
I am an adult female currently employed by a public investment corporation, SOC Limited, as company secretary. Save where the context indicates to the contrary or where it is otherwise stated, the facts contained in the statement are within my personal knowledge and are to the best of my belief both true and correct. I confirm that I made the statement voluntarily without any coercion to assist the work of the Commission of Inquiry. I was requested by the evidence team to address specific matters, which I will do in the subsequent paragraphs. As a governance professional and an officer of the court, not only is it necessary for me, as requested by the evidence team, to assist this commission, but I have a legal obligation to assist this Commission of Inquiry by addressing some of the key issues envisaged in the Commission's terms of reference.
As a government
professional.
What is that? Can you just elaborate on it?
I'm a company secretary. I am also affiliated with the Chartered Secretary of South Africa. My education background and affiliations with professional bodies. I hold a BProp degree from the University of Limpopo, the then University of the North. In 2008, I obtained an LLM degree from the University of South Africa with specialization in commercial law. I also possess a certificate in advanced corporate and securities law, also from the University of South Africa. I am an admitted attorney and conveyancer and was admitted as such in the year 2000. And I then became a member of the Law Society of South Africa, now the Legal Practice Council. I'm also a member of the Chartered Secretary Southern Africa. In 2017, I wrote and passed Level 5 regulatory examination for representatives in terms of the FIRST Act. My work experience. Before joining the PIC, I worked for the following organizations. Mangwe Mahabani Attorneys as a candidate attorney where I served my articles of collection.
What is that in Pretoria?
In Limpopo, in Bulwane. Mangwe Incorporated as a director after my admission as a practicing attorney and conveyancer. The University of Limpopo as a legal advisor. Rose Agency Limpopo as a senior manager, legal services and company secretary. This is where I developed a keen interest in corporate governance as I was single-handedly responsible for establishing the company secretary business unit with the coming to light of the Companies Act 71 of 2008, which made it...
Just as a matter of interest, as a legal advisor at the University of Limpopo, what did your work entail?
My work entailed, I was actually working very closely with the Vice Chancellor and the executive management. So it entailed advising the university in matters of legal advisory, labor matters, and yeah. So it was basically legal services, but I was working very closely with the Vice Chancellor, then Professor Mokhalung. Yeah. And then I was still on the Rose Agency Limpopo as legal services and company secretary. This is where I developed a keen interest in corporate governance as I was single-handedly responsible for establishing the company secretary business unit with the coming to light of the Companies Act 71 of 2008, which made it compulsory for state-owned entities to appoint a company secretary. Also, Limpopo Economic Development Agency as group company secretary. And then I joined South African Express Airways, SAX, as a company secretary. Whilst I was at SA Express, I was part of a team in the Department of Public Enterprises, which was tasked to review the protocol on corporate governance in the public sector during 2015. My role at the PIC. I proudly joined the PIC in August 2015 in the position of company secretary. At the time of my appointment, the CEO was Dr. Daniel Majila, and the chairman of the board was Mr. Mcebisi Jonas.
If I may intervene there, how did you join the PIC? Was the position advertised or what happened?
As I understand it, the position was advertised, but the way I was actually approached by a consultant, an HR consultant from Deloitte. They requested for my CV, then I submitted my CV.
You may proceed.
Thank you. My role.
No. Were you interviewed?
Yes, I was interviewed. I went through the recruitment process, Commissioner. Yeah. My role as company secretary is to oversee and provide a company secretariat service to the board in line with the provisions of Section 86 of the Companies Act, amongst others which are to ensure compliance with the provisions of the Companies Act and the company MOI, to also ensure induction of new board members and to develop a mechanism for providing continuous development for the board, to safeguard the organization's integrity as well as promoting ethical behavior. In 2016, I championed together with my team the establishment of a code of ethics with a task team which comprised representatives from all divisions in the PIC. The board approved code of ethics policy was approved by the board on the 27th of May 2016. After the approval of the policy, this is something that I really was a highlight for us as a team. After the approval of the policy was then workshopped at board level. One of the key things that happened was that at the implementation of the policy was that all board members were requested to sign an oath and pledge to abide by the policy, which they did. I'm also
A
responsible.
question, yeah, sorry, just a question. What is the difference between a board secretary and a company secretary? You know, Vilna does something else, you do something else. What are the differences there?
So I'm not going to dwell much on the actual differences. So Velna does the administrative part of it as a board secretary. I am the company secretary appointed in line with the Companies Act. So Velna reports to me. Yeah.
Okay, oh, all right, okay, thank you.
Sorry, just while you're on your point of 11.3 and you indicate that the board members were required to sign a pledge to abide by the policy, I'm assuming that this was not only the board that had to sign the policy. Management would have had to, it went through the organization. Is that correct?
Certainly, Ms. Commissioner.
Okay. And then can I take you back to 11.1 and the question of compliance with the provisions of the Companies Act and the company MOI. But we have heard before this committee that the MOI, in fact, has been breached by not having a CIO, a COO. What steps did you take, if any, in relation to the board with regard to compliance with the MOI?
Okay. So the issue of the MOI non-compliance in terms of the executive structure was done in 2015, just prior to my appointment. So, but immediately after my appointment, I actually queried whether the MOI was amended to ensure that that was in line with the current structure at the time. And I was told that submissions were made, which I actually also saw to the minister then. But for some reason, those recommendations were never signed by the minister. But I'll also deal, Madam Commissioner, with the other attempts to try and amend the MOI later in my subsequent paragraphs.
The question is twofold. Amending the MOI to cover the breaches is one thing. The question of the breaches themselves and how appropriate they were, was there any discussion about why the CIO, COO positions were done away with, and was there any discussion in the board as to acceptance or otherwise of that? It's not just whether the MOI was amended to make it compliant, it's whether, in fact, those things ought to have been done away with in the first place, and whether the board discussed that.
Okay. Yeah, I believe there was, as I said, that was prior my appointment to the company. I believe there were those discussions, and I think we can ascertain, you know, what.
No, I don't want to go back in that. I want to ask in relation to when you were there and the company secretary, because the breach continued. And therefore, if there was neither an amendment to the MOI or there were proposals to amend to make that acceptable, or the fact that it was simply allowed to continue by the board is what I'm looking at. There was no discussion during the period that you were there about this, if you like, non-compliance and the fact that it was either approved or not approved or disagreed with. by the board?
There were no discussions,
Thank you.
Madam. Yeah. I'm now at paragraph 11.4. I'm also responsible for governance administration, which entails developing an annual board plan and other strategic issues of governance administration, which includes but is not limited to keeping, producing, disseminating minutes of board and committee meetings. Also, this includes providing company secretariat to support EXCO and its subcommittees. At the time of my appointment, I was also responsible for the function of processing and implementation of the appointment of PIC representatives to boards of investee companies in line with the governance policy.
On this matter, you do deal with that much later in your statement. Is there anything you want to bring to attention here, or would you deal with it later when you deal with it towards the end of your statement?
If it pleases the Commission, I'd like to deal with it later on in my subsequent paragraph. Thank you. On 17 April 2018, I was suspended by the PIC on allegations that I caused distribution and or copying of confidential information to unauthorized persons. The allegations against me were that I leaked draft board minutes, which related to the allegations of impropriety against the former CEO, Dr. Daniel Machila's facilitation of payment by a PIC investee director to a third party. I will, in my subsequent paragraphs, deal with how that particular aspect of the minutes were substantially deleted, thereby sanitized from the original draft of the minutes. I will also deal with the full particulars of my charge sheet later in detail. My disciplinary hearing commenced on the 11th of September 2018 and was concluded on the 18th of February 2019. I will also deal with what transpired before, during, and after the disciplinary hearing in the subsequent paragraphs. Introduction. The evidence team requested me to assist the work of this commission of inquiry with specific matters relating to the following: how the board dealt with the anonymous allegations, the process followed and actions taken on the IO and Sagarmatha transactions, the prevailing MOI, how employee functions are constantly changed at the PIC, and the lack of transparency when implementing such, the delegation of authority review process, approval of incentives. The manner in which the board dealt with the whistleblower allegations. The whistleblower allegations that were sent via emails on the 5th of September 2017. On or about the 5th of September 2017, an anonymous email from one James Nugu was sent to various people within the PIC with the title PIC CEO Funds Girlfriend. I have no idea who James Nugu is, since I had made no irregular disclosures to any person of any of the information mentioned in that email. I'm not responsible for the leaks that informed the email. I refer to the author of the email as a whistleblower because it is clear from the detailed content of the email that this person is likely an employee of the PIC making disclosures or allegations of serious wrongdoing, albeit in a highly unorthodox and scathing manner.
Just a question. Some people have speculated that this person could be inside the PIC, but a director of the PIC. Not an employee, sort of a director level person, board level person.
Yeah, thank you, Commissioner. I think for me, the way I've made an assessment, that's my own personal assessment. I believe it is an employee if you look at the content of the two emails in terms of what the allegations were about. It could be board members, but I believe they were working with employees if it was board members, yeah.
And besides belaboring the point, could it be from the investment side, the IT side, you know?
I don't want to come to that speculation, Chair, but I think it's an employee. If you look at the nature of it, it covers investments, it covers the financial relating to salaries, it covers victimization, so it's a whole range of aspects. So it could have been anyone. Yeah.
Yep.
Okay. I must also explain why I think the allegations were from a person who is likely a PIC employee. The allegations made reference to an internal process of the funding application and CSI application by MST, and the payment request of 300,000 by the CEO to an investee company director. They also spoke about victimization of employees by the CFO, Ms. Matsepo More, and the disparities in salary increases. This, in my view, could only have been directly known by PIC officials. The email of the 5th of September 2017 was brought to my attention by Ms. Lindiwe Toyi, a board member, through an email. She requested me to ask IT to check whether the email she received was not a scam. I then forwarded the email to the then executive head of IT, Ms. Vuyoka Zimei, and requested her to address the concerns raised by Ms. Toyi. It was at this stage that I learned from Ms. Menye that she had already been instructed by the CFO, Ms. Masepo More, and the executive head of HR, Mr. Christopher Polwan, to block the email as it had been sent to all PIC employees. On the 6th of September 2017, Dr. Xolani Mkhwanazi, the deputy chairman of the board, requested me to meet with him in my office, where he drafted the letter to Dr. Majila regarding the allegations of corruption by the PIC CEO. In the letter, Dr. Majila was requested to respond to serious allegations contained in the email. The matter was initially scheduled to be discussed at the Directors' Affairs Committee meeting, which was scheduled to be held on the 14th of September 2017. However, it was later agreed that given the seriousness of the allegations, the matter be referred to a full board sitting for speedy resolution. The meeting was meant to be chaired by Dr. Mkhwanazi as chairman. Mr. Sfiso Buthelezi at the time was out of the country. It should be noted that the cancellation of the DAC attracted a lot of negative media attention. The issue of changing the DAC meeting into a board meeting was also questioned by Dr. Majila and some board members who wanted an explanation why the DAC meeting was changed to a board meeting. The chairman gave an explanation that due to the seriousness of the allegations and to ensure that the matter is resolved speedily, it was deemed prudent to deal with the matter as a full board. The query of why DAC was changed to a full board was not warranted, as the DAC matters are delegated to it by a board, and discussions of any matters delegated to a committee by a board may be discussed by a board if it deems prudent. This was explained by the chairman. The whistleblower allegations were then tabled in that board meeting on the 15th of September 2017. As the company secretary, I was in the in-camera meeting and was responsible for taking the minutes in that meeting. At the start of the meeting, I was instructed to switch off the tape recording. The board was adamant that it did not want the in-camera meeting to have a voice recording. I then decided to take notes of all the discussions in order to enable me to prepare the minutes which would be presented to the board for approval. It must be noted that all meetings that relate to the allegations against the CEO and the CFO were not recorded at the behest of the board. The board proceeded with the meeting, although it was highlighted from the onset that a letter requesting a cancellation of the meeting was received from FEDUSA. Such a letter was never made available at the meeting as part of the official record.
If I may intervene, did the board explain to you why you were asked not to record the meetings concerning the matters involving Dr. Machila?
Yes, the board felt that the discussions were highly confidential, and they then requested that I must switch off the recording. In fact, I was the only one left. All the management were recused from the meeting at that stage.
In that paragraph that you've just read, you referred to FEDUSA. Who is FEDUSA?
I am not so sure what FEDUSA is, but I believe it is a union. It's a federation. It's a union, some sort of union, which I don't know. It is a union.
Okay.
That's all I know.
Does FEDUSA have any authority to request that the meetings of the board be cancelled?
No, they don't.
You may proceed at paragraph 24.
No, can I just ask, are you prepared to tell us who in the meeting directed you to switch off the recording? If you don't want to mention the name, was it a non-executive member or executive member?
It was a non-executive member, but at the end of the day, the entire board agreed that there should not be any recording. So it was. Yeah.
Okay. If I may ask, is there any policy that grants the board a discretion to ask you not to record the meetings?
There is no such a policy. In fact, we do have an SOP, which is a standard operating procedure, which which requires us as the company secretary to record all meetings of the board and committee meetings.
So what you're saying is that the board asked you to do what you were not supposed to do.
Yes.
Of course, you could record by handwriting.
Of course, I could record by handwriting, which is what I did, yes, Commissioner. Yeah.
Okay, you may proceed at paragraph 24.
When
Can I just a question, just to come back on James Nogu. Do you think that email came because there was some build-up of, angst about the PIC, things at the PIC, or it just came out of the blue and just somebody just wrote the email?
I think I'm going to speak out of ignorance here, Mr. Commissioner, and I don't think there was a build-up of some sorts. Maybe it's out of my own ignorance. I think it came out of a blue. I think if you read at it, it actually says that people were now fed up in how the PIC was run. So it's something which was brewing at the PIC, I believe, So it's not something that just was, I think it was something that those employees, whoever they are, they felt that, maybe it was the right time now to voice, their concerns. Yeah.
It could, of course, have arisen as a result of dissatisfaction relating to bonuses not being paid or not being sufficient and so on. And people thinking that the executive people are getting their bonuses, whatever the size was.
Yeah, Mr. Commissioner, yes, it could have been. Now that I'm thinking about it, it was during that time that the salary increases were just implemented. So it could be also that those who were voicing those concerns were those employees who were affected in terms of those salary increments. Yeah. When I'm on paragraph 24, when asked, I stated to the board that my view was that the matter was a whistleblower allegations and ought to be treated as such. However, this proposal was rejected by the majority of the board. There was a clear divergence of views in the board in dealing with the whistleblower allegations. This I say due to the following. One view suggested that the board be prudent and err on the side of caution, and thus for the matter to be dealt with by an independent person. This view was informed by the fact that the CEO and the CFO were both implicated in the allegations, and that as executive members of the board, potential associated conflict of interest arose for the board as well. According to this view, an independent objective fact-finding process needed to be embarked upon. The matter was in the public interest, as it had already been reported in the media that there were plans by the board to remove Dr. Majila. Another view was that the board should seek a legal opinion whether an external investigation was not warranted in order to ensure that the board is properly advised on how to deal with the matter. The majority of the board did not agree with this proposal, and the matter was then abandoned. When requested to advise the board, the head of internal audit, Mr. Nema Govani, took the board through the process ordinarily followed in instances where allegations are leveled against any PIC official. Mr. Nema Govani indicated that internal audit lack of forensic expertise to deal with the investigation internally, and his discomfort to investigate the CEO whom he reported to. Another issue raised by internal audit was that the CEO will be required to sign off for any procurement process pertaining to the matter, and it will not be ideal for the CEO to sign off on procurement once the investigation pertains to him. Internal audit recommended that the board appoints a company with forensic investigation expertise, which the board agreed to. The board then took a resolution to appoint an external forensic investigator to investigate the allegations. Internal audit will work in consultation with Ms. Sandra Beswick, a member of the Audit and Risk Committee, since the chairperson of the Audit and Risk Committee, Ms. Tanta Swafubu, was also implicated in the allegations of the email circulated on the 13th of September 2017. I will deal with this.
I'm trying to keep up. I'm trying to read with you, but you are too fast for me. Are you able to slow down a little?
I will slow down, Mr. Commissioner. Apologies. Internal audit recommended that the board appoints a company with forensic investigation expertise, which the board agreed to. The board then took a resolution to appoint an external forensic investigator to investigate the allegations. Internal audit was to work with Ms. Sandra Beswick, a board member of the Audit and Risk Committee, since the chairperson of the Audit and Risk Committee, Ms. Tanta Swafubu, was also implicated in the allegations of the email, which circulated on the 13th of September 2017. I will deal with these email allegations in the paragraphs to follow. Still at the 15th September 2017 meeting, the board then called the CEO and CFO back into the meeting and communicated the resolution of the board to appoint an external forensic investigator who will investigate the allegations. The CEO and CFO protested against the decision of the board. They argued that the allegations against them were nothing but malicious. They had difficulty why the board will resolve to conduct an investigation on allegations which were direct attacks on them and were not received through the normal PIC whistleblowing channels. They also told the board that they had prepared responses to all the allegations. So why was the board not considering their responses and deciding to conduct an investigation? The CEO then started to complain about the leaks and the suspected hacking of PIC IT systems, and said the board needed to look into those issues rather than those malicious allegations. It was after the presentation by Dr. Majila and Ms. More that the board then changed its original resolution to conduct an independent investigation into the allegations. I was requested to recall the head of internal audit, who was advised by the board that the original resolution to conduct a forensic investigation had been rescinded. He was further advised that the board accepted the explanation given by the CEO and the CFO. Internal audit was now required to embark on a review and verification process of the documents which were submitted by management. And the board specifically emphasized that the review process should not be an independent forensic investigation exercise, as they had initially resolved. Internal audit was specifically requested to test the validity, accuracy, completeness of the documents submitted by management, which actually basically entailed an internal review of whether applicable policies, procedures were complied with in approving funding to MST. Internal audit was to be provided with a scope, internal audit was to be provided with a scope of work, which was delegated to be signed off by Ms. Beswick. As I've already indicated, the chairperson of the Audit and Risk Committee was conflicted on the matter. Internal audit was therefore required to report to the board at a subsequent scheduled meeting of the board, which was scheduled to be held on the 29th of September. I was also asked.
Let's check something here. It was quite difficult, in the sense that the board is here and the CEO and the CFO say, before you take it to outside parties, we have some answers we can give to you, And I know you do disagree with how the board did this, but I mean, if you are accused and the board says, look, we want to give you a chance to state your case, and if we are not happy with what you say, then we can take this to outside bodies and all that. So I guess it was quite a difficult situation. But what do you think about that?
Mr. Commissioner, my view is that I believe that at that stage, even when the board took the resolution to appoint an external person, the board hadn't reached any view on the matter. And I say it was a correct approach because then the board is not clouded. It was just merely allegations. No executive was said to have done anything wrong at that stage. And I think one of the critical aspects is the fact that the executives themselves are part of a board. They are also board members. So it would have been crucial to get an external person to have a view first before, which is, I think it was one of the advice that was also given by one of the board members to say that the board has not taken a view. No one is going to be suspended at this stage. We just want somebody to test, independently. the allegations. So I think that is the view that I also felt would have been correct.
I'm just trying to find out, because I'm thinking if there's a problem internally, wouldn't it work better to give the people a chance internally first and then see whether you are happy? If not, then really take it to outside parties. I'm not sure I'm getting you there.
So Commissioner, if you look at the totality of the allegations, there were allegations that dealt with how the process was followed in approving the funding. That part management had responded to. And I believe the board was given those responses. They had looked at those responses. There were other allegations, the nature of which, and correctly, internal audit had already advised the board that these kind of allegations, we don't have the capacity internally to look at. So it was quite prudent for the board to have, sought independent, investigation on those allegations. So remember, management already had been given an opportunity to submit their responses, which they did. So there were 2 allegations, if you think about it.
Yes, yes. So there were parts which could be done internally maybe, and there were parts which couldn't be done internally. Is that what you're saying? No?
What I'm saying is that the management were given the opportunity to respond for the parts in terms of documentation and everything which they submitted. And the other allegations which related to which needed a forensic investigator were to be investigated externally. I still believe that by the virtue of the fact that internal audit had already advised the board, internal audit reported to the CEO who signed his balance scorecard. It wouldn't have been prudent for the board to expect internal audit to be investigating his own boss. The executives also are members of the board, so it would have been quite, for me, the correct approach to get an external person to verify, whether it's to verify the documentation that was submitted or to even embark on a full-scale forensic audit of the allegation.
All right, thanks. I get it, yeah.
Okay. I'm on paragraph 28, Mr. Commissioner. I was tasked to prepare the scope of work in consultation with Ms. Beswick, which was eventually signed off. It is important for this commission to know that the allegation regarding the possible relationship between the CEO and Ms. Low was explicitly excluded from the scope of work. Also to be excluded was whether the CEO instructed a director of an investee company to pay the debts of Ms. Low's struggling business.
Just on that question, were these matters discussed in the board itself? Those 2 points that were excluded?
At that stage, Madam Commissioner,
there had been no discussion on it at all?
There were no
They were just excluded from the investigation without the board discussing them at all?
Correct, ma'am. Yeah.
Can I just ask you, for purposes of the record, when you have an annexure, to just mention it?
Oh, I will do so, Commissioner. Thank you. And the scope of work, Mr. Commissioner, is actually annexed BM5 in the index. I'm on paragraph 29. The sudden about 10 of the board, after thoroughly debating the matter and coming to a conclusion to forensically investigate the matter, seemed questionable to me, especially since the about 10 came at the instance of individuals against whom allegations had been made and in the face of internal audit's stated lack of forensic capacity to properly pursue the investigation. The board adopted a holistic approach, and internal audit was further tasked to conduct the same review and verification process with specific reference to another email with a new set of allegations, which was circulated on the 13th of September 2017. That is Annexure BM6. All implicated parties were to submit their responses to internal audit by the 22nd of September 2017, according to the board resolution. The internal audit report on the allegations dated the 13th of September was to be submitted to the board by the 22nd of October 2017. It is perhaps important for this commission to know that there was a dissenting view by a board member, Ms. Sibusisiwe Zulu, on record, who did not agree with the board's resolution on the matter. Ms. Zulu's reason for her dissenting view were due to the following. The process being followed by the board in conducting the investigation was flawed and stood to be challenged. The head of internal audit had expressed these reservations that the matter is not the type of the investigation that is conducted internally. He had recommended that this be conducted by an external independent forensic investigator. Despite this advice and discomfort raised by internal audit, the board still insisted for internal audit to conduct the review process. It was incorrect for the board. I'm still continuing in terms of the dissenting views. She also raised the issue that it was incorrect for the board not to investigate the matter properly and completely on the basis that it does not consider it as a whistleblowing report. The report, according to her, was a whistleblowing and required proper investigation by the board in order for the board to make an informed decision. The participation of executive directors in some of the board deliberations and or obtaining their views prior to the board making its final decisions on the matter was an irregular process which stood to be challenged. And the board contradicted itself and could not have concluded that it is satisfied that the CEO provided detailed documentary evidence and was satisfied that the process followed was in accordance with all policies, procedures, and delegation of authority of the PIC, whilst at the same time referring the matter to internal audit for review. Ms. Zulu also cautioned the board that the allegations were broad and the board needed to be seen to be acting on the allegations. After the meeting of the 15th of September 2017, the board issued a media statement indicating that it had accepted the representations made by the CEO. This caused two questions why the board went ahead with internal audit review if it had already accepted representations by the executive directors. This appears to me to be just one of a number of examples where the board fell in line with the CEO's insistence on exoneration when the board's oversight duties clearly demanded more professional skepticism. It could be said to be contradictory as one cannot come to such a conclusion in the absence of verifiable evidence. I'm going to now deal with the whistleblower.
Yeah, let's check something here. Just to get a view from you, we heard from one board member some time back that this was the time of state capture and that the board had to support the CEO because, you know, they were worried that the state capture people wanted to fire the CEO. Do you have any views about that? Can you recall the events during that time?
Mr. Commissioner, what I recall at the time was that there were a lot of media articles about possible state capture of the PIC and all sorts of things, you know, negative publicity for the PIC. I don't have any personal knowledge of any issue of state capture. Maybe that was just beyond, you know, my pay grade, but I don't recall any sort of official discussion on state capture. If that was done, it would have been done maybe unofficially outside, you know, official discussions. Yeah.
To follow up, when I asked some time back that there was, it appears that there was a meeting where Minister Gordon told the board or some people that they must be aware of state capture, but I cannot recall whether it was a board meeting or something else. Can you recall that? I mean, you were in board meetings, General.
Yeah, yes, Mr. Commissioner, that was in it was the AGM, it was the annual general meeting of 2015 or 16. I need to check my records correctly. It was not in 2017 when that happens. Minister Gordon, as the shareholder representative at the time, he did, you know, make that kind of pronouncements when he was in his opening remarks. The fact that the PIC needed to be mindful of state capture, but as I said, it was not in 2017 when this whole issues were happening. So I can't link the 2015-16 discussion with Minister Gordon at the time to what was happening at this period in 2017. Yeah.
So broadly, according to you, you're saying you are not aware and this is beyond your pay grade, really?
Really, in 2017, Mr. Commissioner.
Okay.
Yeah.
All right. Okay.
But perhaps just a point of clarity there, Minister Gordon's statement was a public statement, it wasn't in a closed meeting.
It was in the annual general meeting of the PIC.
Open meeting.
In his opening remarks, yes. So I'm gonna deal, can I continue? Okay. In paragraph 34, the wide-ranging allegations from Leihlola contained in the email of 13 September 2017 implicated the CEO, the CFO, former chairperson of the Audit and Risk, executive head of HR. The allegations raised concerns about...
Can you just remind us who the former chairperson of ARC that is being referred to here?
It's Ms. Tantaswa Fubu. The allegations raised concerns about remuneration and bonus incentives, corrupt deals, investments, victimization and ill-treatment of the staff members, nepotism and buying off. The allegations also called for a lifestyle audit of the CEO, CFO, and some members of EXCO. A plea was also made for the board to have a protected meeting with staff members in the absence of the CEO, CFO, and executive head of HR. Internal audit was also mandated by the board during the meeting held on the 15th of September 2017 to conduct the same review process with specific reference to allegations from Leihlola contained in the email dated the 13th of September 2017. As the company secretary, again, it was unclear to me how the board intended for those type of allegations to merely go through a verification process by internal audit. This, in my view, required an investigation and for employees to be given room to disclose all their concerns and grievances relating to incentives, victimization, etc. This view is supported by what I've seen through this commission, that for the first time, employees have been able to come out and state their concerns in relation to employee matters and allegations of victimization. It appears to me that the board was clearly not keen to make this remedy available to employees, to enable them to air their views and complaints about the conduct of implicated executives. In fact, this was confirmed by the resolution of the board on the 6th of October 2017, where the board resolved to terminate the internal audit process, which was verifying the allegations. The board's view at the time was that these allegations were baseless and malicious.
Sorry, can I just, for purposes of clarity, try to just understand the sequencing? So in the first instance, the board agrees for an external investigation. It rescinds that and asks the internal audit to do a verification process.
Yes.
And then rescinds that verification process on the grounds that this is simply malicious.
Yes.
So there were 3 steps of changing the mind by the board.
Yes.
Whether that was unanimous or not it was the majority decision, so that was what carried. Was it, these were not unanimous decisions, or were they in the boards?
Of course, there were dissenting views and different opinions, but at the end of the day, the majority of the board took the resolutions.
So that in that, just to be clear, there were 3 distinct activities by the board that changed its mind.
Yes, but this, remember, is not happening in one meeting.
No, I'm saying 3 distinct times.
Yes,
Yeah.
yes, certainly, Madam Commissioner.
Thank you.
Yes.
Okay, if I may ask you, who was the chairperson of the board in September and October 2017?
It was Mr. Sfiso Buthelezi. He was also the Deputy Minister of Finance at the time.
Okay, can I ask you again, did the board or the majority of the board give any reason why they were terminating the internal audit process?
Yes, one of the reasons they gave was that they wanted to restore stability, and I deal with it as well later on in my subsequent paragraphs, but also the fact that those allegations were malicious and baseless.
You may continue at paragraph 37.
Okay, thank you. During the same board meeting of 15 September 2017, the issue of information leaks was delegated to the Information Communication Technology Governance Committee, that is the ICTGC. This committee, however, did not take charge of the matter. Instead, the same executive management that were to some extent implicated in the Nogu and Leihlola allegations was tasked to deal with the information leaks as a matter of agency. This had the effect of involving the management in a manner where they were clearly, in a matter where they were clearly conflicted.
Okay, if I may intervene, who delegated the issue to the Information Communication and Technology Governance Committee?
The board on the 15th of September.
then when the executive management took over, was the board informed of this?
I would believe the board was later informed because on the 29th of September, the CEO reported back to the board on the fact that they had now appointed an IT company to look into information leaks.
Okay, you may continue.
Okay, let's just check your view broadly about these issues. Do you think that if the board had taken the route of an external investigation, all these issues about the firings of the Menyes and the Maisela, and you also could have been avoided if it was a different process to the one which prevailed?
I honestly believe it would have been so much different. It would have been handled differently because first of all, management wouldn't have been part of the process, and all the conflicted parties, including some, members of management, the HR manager, the HR executive as well was implicated. The HR executive was also one of the people who was, steering all these disciplinary hearings. So I truly, really believe that if it had been taken out of the PIC process, it could have been handled much better.
So it could have been a different PIC by now if James Nogu email this commission probably wouldn't be here. Is that what you're saying?
Look, Commissioner, for me, I'm talking about the specific allegations. Look, there are issues at the PIC, which I believe the commission is handling at the moment, which I don't believe is linked to this particular issue. Without the fact that the hearings would have been handled differently, I don't think there were certain issues at the PIC which were happening in terms of victimization, salaries, and all those other things, which I believe that the fact that the Commission of Inquiry we are currently sitting here now, it also shows that there were certain things that also needed to be dealt with. Whether the investigations would have dealt with those issues, I don't know. But on the aspect of the hearings, I believe that things would have been handled differently. Yeah.
Thank you.
Okay.
Can I just, Ms. Matebul, can I just take you back to paragraph 33 of your statement? You mentioned there that the board, after the meeting of the 15th September, the board issued a media statement indicating that it had accepted the representations made by the CEO, right? And then in paragraph 36, right at the end, you say the board's view at the time was that these allegations were baseless and malicious. What was the basis of that now? Because after they had accepted the explanations or representations, the board was okay with the continuation by the IA in verifications. Am I correct?
Mr. Commissioner, so yes, you are correct partly. There are two sets of allegations. The first allegations of the 5th of September, which the board dealt with in that meeting on the 15th of September, where the board, after that meeting, they had then resolved for internal audit to conduct the verification process. That was when the board issues the media statement on the 15th of September.
That's in relation to
the James Nogu allegations. The other part in paragraph 36 relates to the other allegations of the 13th of September, the allegations by Leihlola. Yeah. Okay. I'm on paragraph 38, Mr. Commissioner. After the James Nogu email, the CEO started investigating the source of the leak of information. Ms. Menye and Mr. Noma Gobani were also instructed to have a criminal case opened in relation to the leak. I became aware of this instruction because they came to my office to request that I finish them with a purportedly classified document with respect to the MST transaction. I could unfortunately not assist them as the originally submitted submission from the investment team was not classified in the first place.
Sorry, I don't understand that, and it just might be a lack of appreciation of the process. Because if it was not a classified document, surely they would have had access to it anyway. They didn't need you to provide it. It would have been something that they could have obtained from you or anybody else because it was not a classified document. So did they get the document or not?
Madam
did not.
Commissioner, no, they never got the document.
Why not if it wasn't? Was it something that was then refused to them by somebody? You couldn't, if I understand your sentence there, is that you could not help them because it was not in your documentation as classified.
Yes, Madam
But it was
Commissioner.
available elsewhere in the organization.
It was not available elsewhere in the organization. Maybe just to also to put context, Madam Commissioner. So what happened is that the CEO had then instructed, I later learned that the CEO had then instructed Ms. Menye and Mr. Nomagovan to go and open a case at the South African Police Services. When they got there, the police requested that they cannot open a case if they don't have a classified document pertaining to the matter. Hence, they came to my office, and that document they never found. It was never there at the PIC. So hence, they couldn't open that case. I don't understand the SAPS process, but it looked like that's what the SAPS wanted from the PIC, for them to
But
open
there are
that.
two elements here then to understand that. In order to open up the case of documentation misuse, the SAPS has to say that you have taken a document that was classified.
Yes,
Right? Because the document was not classified, they could not open the case.
certainly.
But what you're also saying is there was no such document.
Correct, Madam Commissioner.
Okay.
Yeah. Okay. I continue. Okay. I also, paragraph 39, I also listened with surprise and dismay to the testimony of Ms. Menye before this commission, stating that the CEO took it upon himself to find the identity of the whistleblower, and in the process instructed and entrusted external service providers to spy on certain executives, including myself. Aside from the breach of IT protocols, which Ms. Menye has highlighted in testimony to this commission, it seems irregular that the CEO will so closely direct an investigation into matters in which he was implicated.
Just coming back to the question of, and we've had this evidence before, but if you could just indicate when it is instructed external service providers to spy on certain executives, does that mean there were recording devices? How was the spying to take place? Or how did it take place?
I believe in my mind that, Commissioner, it would have been recording people, you know, looking at the emails of the people. I think I'm also talking on the basis of what I've heard before this commission of inquiry, that the emails, for instance, my emails were also spied upon, which, you know, was something which was not the right thing to do without me giving permission for such to happen.
Can we just look at this subsequent to this and have just a bit of a discussion? Because this is quite, to me, quite a breach. If there is something within the PIC that says, given the nature of it, they have the right to look at staff emails, or whether this was actually listening devices, contact or email communication, what authorization to an entrusted external service provider would have been required to enable them to do that?
It is noted.
Can I add? I think, if I recall, Ms. Menye didn't mention recordings. She spoke about the emails, and that I think the hard drives or something, they were taken or something, you know, there was something about the emails that they were being accessed without you people knowing about it. Are you saying there could have been recordings also, which is a completely different matter to record phone calls and all that?
Well, my view is that if they were spying on emails, maybe there could have been. I'm not saying there was. I'm saying maybe there could have been even, you know, listening devices. But what is before this commission certainly is the fact that emails were spied upon. Yeah.
Yes, okay, all right.
Okay. 40.
That first part of that paragraph, it seems to me that you are saying this is what Ms. Mania testified to in this commission. Am I correct or not?
Yes. Paragraph 40, Mr. Commissioner.
No, sorry, just on that. Was this the first time you were aware that you were among those being spied upon?
To be honest, Madam Commissioner, I had heard the rumors that I was also being spied upon.
Sorry, just say that again.
I heard the rumors that I was being spied
You'd heard
upon.
rumors, but this was the first
But this
time
was the
you saw
first
the
time.
evidence.
Yes, this was the first time. 40. Paragraph 40, that such a profound conflict of interest will arise, I submit should have been obvious to the board and Dr. Majila and ought to have been mitigated against. The rescinding of its original board resolution, in my opinion, was an oversight, as it had the unintended consequence of targeting of individuals that were randomly identified as possible leakers of information.
If I may intervene, you say in the first sentence of that paragraph that such a profound conflict of interest would arise, would I submit, should have been obvious to the board and Dr. Majila and ought to have been mitigated against. Was the board aware that Dr. Majila had was investigating the source of the leak of the information?
Of course, the board would have been aware because the board delegated to its committee, and the committee then delegated management to do those investigations.
Okay. You, earlier in your statement, you said Ms. Fubu couldn't deal with a certain issue because she was also implicated. Did the board express any concern about Dr. Majila being conflicted in the investigation of the source of the leaks of the information?
Surprisingly, the board didn't pronounce any discomfort for Dr. Majila, who was also conflicted. However, the board then could see that the chair of audit and risk, who was implicated, was conflicted, hence she was not going to participate in any of those investigations. So that for me also is another issue.
You may continue at paragraph 41.
Okay. The CEO reported to the board during the meeting held on the 29th of September that BCX and Telcom were appointed to investigate information leaks and to assist with IT security. It was clear that the board had permitted the CEO to take charge of the investigation into the source of leaking of information. This was done without having regard to the evident conflict of interest by the CEO and other implicated executives, especially the executive head of HR, who was later tasked with running with all the disciplinary matters linked with the leakage of information.
Mr. Commissioner, it's 11 o'clock. Is it a convenient time to take the adjournment?
You want to.
Yes, we'll adjourn until 20 past 11. Ms. Matebula, are you still under oath?
Yes, Commissioner.
You may continue.
Yes, you may start at paragraph 42 on page 14.
Okay. Thank you.
Ms. Matebula, before you proceed, just another question before we leave this area.
Okay.
Just in terms of the two paths, you know, we sort of agreed that there was the internal path and the external path, which was supposed to be taken. And the board decided to take the internal route. Do you think when the board took that decision, was it just a mistake, sort of with hindsight? Was it just a issue of mistakes, or there was just, the board was confident that it's taking the right decision? I don't know whether I'm clear, but I mean, do you think it was an honest decision, honest mistake with hindsight in some ways, or something different?
If you are able to answer that question.
Mr. Commissioner, I can answer, but this is my own personal views. I do not believe that it was an honest mistake. The board was cautioned on several occasions on, you know, the appropriate route to take in that respect. First of all, the board disregarded the fact that it was a whistleblowing report. They didn't want to hear that. Second of all, the board was also cautioned on to say, let's just seek legal advice or legal opinion on this matter. It would have been much more appropriate, and having been at that board as a company secretary, I've seen instances where the board took resolutions to go for legal opinions. And I believe that that would have taken out any sort of subjective, you know, insinuances which I observed as a company secretary. So my honest view, I do not believe it was an honest mistake. I think there were influences. Where those influences were coming from, I cannot tell. Yeah.
And so you think that the board, the best the board could have done is to get a legal, you know, the advice on what to do, and then follow from there?
Precisely, Commissioner. The PIC does have a mechanism where the board can seek advice and the PIC pays for those. And it has happened quite a number of times. Where the board is not sure or certain on the route to take, I believe getting an external opinion will be better approach.
Yeah. Thank you very much. Yeah, that's good.
Can I start? Okay, I'm on paragraph 42. The internal audit report, that is Annexure BM7, regarding the allegations on the loan provided by the PIC to mobilize satellite technologies, was presented by Mr. Nemagobani during a board meeting held on the 29th of September, 2017. It should be noted that there was no PIC prepared for this meeting, and the matter to be discussed by the board was, for me, not a run-of-the-mill. I was in attendance at that meeting taking minutes, so it was prudent for me to capture the true proceedings of the discussions at the meeting. I also did not want to second-guess the discussions of the board and confine the minutes to only the resolutions taken at that meeting. During the presentation of the internal audit report, it was evident that the internal audit did not conduct an evaluation and audit of the conduct of Dr. Majila in requesting Mr. Lawrence Mulauzi to make a payment of 300,000 to settle the debt of Ms. Pretty Low's company. This was due to the fact that this aspect was specifically excluded by the board in the internal audit scope of work to test the validity, accuracy, and completeness of the documents submitted by management. I had difficulty with the board's approach that although the CEO had prepared a response to the allegations which the board accepted, those responses did not deal with the issue of him requesting 300,000 to be given to Ms. Low. Dr. Majila's submissions to the board only reflected the internal process followed in approving the MST loan and CSI allocation. It therefore meant that the CEO had not fully responded to all the matters or confirmed the accuracy of some of the allegations, and the board still accepted his responses and declared the allegations baseless without independently testing the same. This was one of the issues that had attracted press coverage and public criticism at the time. This was because Mr. Mlauzi is a businessman who had received significant funding from the PIC in the past and whom one could reasonably say was dependent on future funding. Mr. Nemagobane was excused from the meeting and requested to interview both the CEO and Mr. Mlauzi on this limited aspect of the James Nuku allegations. Mr. Nemagobane reported back to the board on his discussions held with the CEO and the telephonic discussions with Mr. Mlauzi. He reported that Mr. Mlauzi had confirmed that Ms. Lowe and her business partner were introduced to him by the CEO, who initially requested him to assist the ladies with business opportunities, which he could not do. Later, according to the version of Mr. Mlauzi, as reported by internal audit in the meeting, the CEO requested him to assist the ladies settle their business debt, which Mr. Mlauzi did by paying an amount of 300,000 in 2 equal installments to the collecting attorneys.
Sorry, can I just interrupt you there for a second? Again, it's a point of clarity. From your testimony here, it would look as if there were then 2 distinct approaches to Mr. Mlauzi. The first was to see whether he could help them with their business activities, and the second one was about a payment transaction of asking him to pay and assist the 300,000. 2 distinct times.
Correct,
Thank you.
Ms. Commissioner. Paragraph 47.
Sorry, Mr. Commissioner, just for the record, and I think it's relevant to the question asked, that was exactly the evidence of Mr. Mlauzi.
Yes, but it wasn't the evidence about how they first met Ms. Lowe.
That is
That's-
correct.
Paragraph 47. When this feedback was given to the board and the chairman asked the directors if this could not be regarded as impropriety, some directors jumped into the defense of Dr. Majila. They went as far as
Sorry,
saying
who was the chairman at that point
it
in
was
time?
Mr. Sfiso Buthelezi.
Buthelezi.
Yeah. They went as far as saying they were proud of what he had done. It showed that he was a thoughtful and selfless CEO who was willing to rescue a struggling entrepreneur. One director even referred to him as a good Samaritan. There was an immediate heated debate and pushback to this response. The deputy chairman at the time, Dr. Mkwanazi, cautioned his colleagues from defending the indefensible. He expressed shock that there were some directors who were willing to justify the actions of the CEO. Ms. Zulu then stated that this was the board's response to if this was the board's response to the matter, she challenged the board to make a public pronouncement to this effect, to see how the reasonable public will receive such a stance. It was at that point that the chairman pleaded with the board members to be honest with themselves and not to be seen to be promoting what could be seen as unethical behavior. The board then accepted the chairman's advice, then resolving that the Social and Ethics Committee should formulate a policy which should have been meant to avoid situations where the CEO or any of the management staff can be compromised, and to ensure that if the CEO wants to make such initiatives, he can do so whilst accompanied by other PIC officials, and that such meetings should be done in a formal and recorded manner. Even at that point, the majority of the board still held a view that the CEO had done nothing wrong, and he just needed to be cautioned about how he handles such matters in the future, so that there is no perception that he uses his influence to assist third parties. Such a policy was never developed, according to my knowledge. My understanding of the way the board deliberated on the impropriety was that the majority of the board did not regard it warranting for formal action to be taken against the CEO, but accepted the CEO's actions risk engendering the perception that he had used his position of influence to improperly benefit another person. Again, a media statement was issued.
Paragraph 47. And I don't know whether you can answer this. If you can, please tell me. The question is, who defended the CEO. You said some people jumped into the defense of the CEO. Can you recall the names, the people and all, if you can answer that?
Okay, Mr. Commissioner, can I not mention names? I can give the names to the evidence leader, if it pleases the commission.
That's fine,
Okay.
that's fine.
Thank you. Sorry, I'm on paragraph 50. Again, a media statement was issued after the board meeting of the 15th of September 2017. That is Annex 8. This media statement made no mention that the CEO's conduct engendered risk and was irregular and out of line in any way. This fact would, however, have been apparent from a perusal of the minutes of the meeting that I will deal with in subsequent paragraphs. All media-related statements and newspaper articles are also attached, Commissioner, under BM 8A. Allegations not thoroughly investigated. The sudden decision to stop any further investigation. On the 6th of October 2017, in Annexure 9, the board held an agent special board meeting. This was immediately after the board strategy session, which was held in Magaliesberg between the 5th and the 6th of October 2017. Again, I was in attendance and I was the one taking the minutes at that meeting. Again, I was also told not to record the discussions. The board took a resolution not to pursue any further investigations of the allegations of the 13th of September 2017 at that meeting. Given the nature and seriousness, this strikes me as a failure by the board to discharge its fiduciary responsibilities in the interest of the PIC.
Sorry, can I just ask you, when the board took that resolution, were any reasons given?
So
Reasons to say we're not going to pursue any further investigations? What were the reasons given?
Madam Commissioner, the reasons given by the board was that the allegations of the 13th of September 2017 were malicious and baseless. But also the board was saying that they wanted to restore stability into the PIC. So those were
Same
the
reasoning as you had given before, but they
Yes.
still did not have any information. They had not got a result of any investigation.
Precisely. Especially since public scrutiny on the PIC, especially the CEO, was heightening. Logic would have detected that the board allowed internal audit process. The board had itself commissioned on the 15th of September 2017 to be completed and not to close this matter properly. Surprisingly, the reason given, again, these are the reasons, to stop all further investigations was to restore stability at the PIC and to focus on the implementation of the mandate of the PIC. What is contrary is that the victimization by management against those who were falling out of line with the CEO was continuing. I need to mention that it was during the board meeting of the 15th of September, Commissioner, 2017, and all subsequent meetings dealing with the allegations against the CEO, where there were serious tensions in the board. The board was clearly divided on this matter. Simply put, it became very clear that there were directors who were prepared to defend the CEO and immediately exonerate him without allowing any due process. There were other directors in the minority who rejected this approach. These directors held a strong view that this matter, if not properly dealt with, posed a serious reputational risk on the board and the PIC as a whole. Although it was only Ms. Zulu who insisted that her dissenting view to what she regarded as a flawed process by the board be recorded, there were strong differences of opinion during the debate on the matter. However, the majority of the board supported Dr. Majila and even releasing media statements endorsing him publicly.
Okay, if I may intervene there. In the last paragraph, or last sentence of paragraph 52, you say what is contrary is that the victimization by management against those who are falling out of line with the CEO was continuing. Who were those people in management who were victimizing employees?
I believe, to my understanding, it was the CEO, it was the executive head of HR, the CFO, the head of HR reports to the CFO, and I do not believe that the HR head was acting out of line without taking instructions or consultation with the CFO.
Okay. When you say they victimized employees, what do you mean? How did they victimize them?
I'm going to talk, thank you, I'm going to talk for myself. At the time the board took a resolution of 6 October, it was the time when all the forensic investigations had started. Although I did not realize at the time the gravity and the nature and the determination to try and find who the leakers of information were. It was during that time when Naledi had been appointed and I had already underwent interviews with Naledi. And then I then realized now that it was the time when the CEO had just started this, witch hunt to try and find who the leakers of information were. So I myself was the one who was, at that time, now being victimized.
Okay. You may proceed.
Yeah.
I'm going to talk.
Just to understand something, so in terms of the board functioning, or functioning well, it looks like we have a pre-NOGU board and a post-NOGU kind of board. Was the board functioning well before the NOGU mails, the emails, if you can recall? Was it not divided? Was it functioning very well? We know post-NOGU there were problems.
Mr. Commissioner, the board was functioning quite well. Even after the NOGU emails, I must say, in terms of strategy, strategy sessions were held, statutory matters were attended to by the board. There was a time when there was a vacuum after the departure of the then Minister Gordon and his deputy minister at the time, Mr. Mcebisi Jonas, before the appointment of the new deputy minister who then later became the chairman. There was a time when, we were still waiting for the chairman to be appointed. I think it was about 3 months at that time. But the board was functioning quite well in terms of approving strategy document, corporate plans were submitted, things that were supposed to be attended to were attended to. So I don't want to say the board was not functioning. It was only when the issues of the allegations were discussed at the board where there was serious divisions and disagreements in the board. Yeah.
Thank you.
Okay, can I continue? Thank you. Paragraph 54. On the meeting between the erstwhile Minister Gigaba and the board. On the 26th September 2017, Annexure 10, Minister Gigaba met with the board to address several concerns in light of the persistent negative media publicity that was confronting the PIC. The minister specifically requested for the meeting to be recorded. What prompted the minister's meeting was an article termed Denmark, they are looking for the keys to the big safe, which was dated the 24th of September 2017. Of concern about the article was that the board had taken a decision prior to the article that any communication with the media should be sanctioned by the board. However, the CEO had taken it upon himself to be interviewed about matters which were seized with the board outside the board. The transcript of the meeting with the minister, Mr. Commissioner, is also annexed, is also attached. The transcript will set the full context of what transpired during the meeting. I was also, by the way, in attendance at the meeting, and I was also then requested to also take the minutes. Okay, that's Annexure 11. Minister Gigaba, as shareholder representative, was concerned that he was being dragged into PIC matters which he had no knowledge of and was being painted as interfering into the governance affairs of the PIC, which he denied. The minister said he had received, in his opening, the minister said that he had received a WhatsApp text on the 13th of September 2017 from a Cape Town businessman, and he read the text out into the record. The text read, I quote, "Hi Malusi, can you call me urgently? My editors have picked up a story on the removal of Dan Majila as PIC CEO at a special board meeting on Friday. I am not sure if you are aware. This will be catastrophic and will set us back. Please intervene to stop this, since it is not good for you and the project. I have also sent FISO a text. I am available to chat anytime.
Okay.
I close quote.
If I may intervene, do you have any idea who this Cape Town businessman could be?
I do not have any idea, but I believe a name was mentioned, and I think it was Mr. Iqbal Seve. And then the minister's response was, I open quote, I am not on the PIC board, chief. I cannot intervene on this, as this is a matter the board has not formally reported to me. My deputy has not told me they have suspended the CEO. I am sure you would understand I have to respect governance, close quote. And then the businessman responded, open quote, of course, I am just trying to help so that it does not embarrass you, the DM and the government. It will also undo all the good publicity you have been getting. I leave it in your hands, close quote.
Thanks. Can I just perhaps go back to the original text and perhaps, Advocate Libber, it would be possible to ask former Minister Gigaba about this and who it was from, so that we can authenticate the source of this call.
It will be
if it's
followed
possible.
up.
I think the second question for me was that if Minister Gigaba is saying the PIC has been dragged into matters, it's clearly being dragged into matters from this by the businessman, not by the PIC or the media. The businessman is dragging the person in, and therefore the question for me would be again to former Minister Gigaba, how did he then deal, apart from the text here, you know, how would somebody be that familiar to be able to do that? I think the third question that I would have, which relates to this, is to understand it's not good for you and the project. What project? Do we have any idea what project he was referring to? And the fourth question is that if it is an issue for the PIC, and I'm assuming that Sifiso refers to Deputy Minister Buthelezi, who would have been the chairperson of the PIC at the time, it is quite extraordinary that a businessman can contact a minister and a deputy minister and a chair asking them to look into this matter. So I do think there needs to be follow-up perhaps by you, Advocate Libber, unless you are able, Ms. Matabula, to indicate what your understanding of the project was and whether there was any elaboration of that in the meeting, and whether any board member actually asked him, you know, with any discussion in the board, what project are you referring to that is being put at risk, given that this was read into the text, and I'm assuming then you have it as a voice recording as well, so this is the actual text, because he did ask you to record that meeting. Is that correct?
Madam Commissioner, yes, it was recorded. We also have it on recordings. The matter was never discussed further at that meeting, so I do not know what project he was referring to.
Just for clarity, although this was put into the meeting with the board did not ask him to elaborate on any level.
Correct, ma'am.
Mr. Commissioner, if I may refer the members of the Commission to Annex BM11. Page 2 of Annex BM11. From line number 19. The minister said, I do not know how, is it not good for me, and I do not know how. What project was he talking to, was he referring to?
The minister is indicating that he did not know what he was referring to.
That is what is recorded.
Thank you.
Paragraph 56. The minister was, paragraph 56, the minister was angry that he was being dragged into PIC internal matters. He requested to be provided with answers on specific matters.
Sorry, did you put that last quote on record?
I did, but I can read it again for the record.
I don't think you did, I'm not sure.
Okay, let me read it for the record. Then the businessman responded, open quote, "Of course, I'm just trying to help so that it does not embarrass you, the DM and the government. It will also undo all the good publicity you have been getting. I leave it in your hands," I close quote.
And the DM is Deputy Minister.
Is a deputy minister. The minister was angry that he was being dragged into PIC internal matters. He requested to be provided with answers on specific matters. Those were allegations against the minister that him and the then chairman, Mr. Buthelezi, and the two newly appointed board members at the time, Dr. Mkwanazi and Ms. Mukoka, were part of a group of individuals deployed to capture the PIC and facilitate the removal of the then CEO. I must say, Commissioner, that the article that I read out that says they are out to get the big safe also mentioned the aspect of the state capture. This was one of the articles which also mentioned the issue of the state capture. The minister also wanted responses on how the board had handled the allegations against the CEO, how the board had dealt with the allegations about the hacking of the PIC IT system, how the board will deal with the misquoting of the statement made by the CEO in his interview with the Sunday Times, ENCA, and any other newspaper. Allegations of interference by the minister in the governance affairs of the PIC, and he requested to be provided with regular reports on these matters. Following the meeting with the board, Minister Gigaba wrote a letter on the 9th of October 2017, that is Annexure 12, to the board as a follow-up and requested the board to attend to several issues following his meeting with the board on the 26th of September.
Sorry, can I just ask a question in relation to that? So can I just have the file? Can I just have the file a second? I just want to refer to something in that file. As you can see, these two files are the annexures, so it's a little bit unwieldy, but I just want to come to the reference that you have there on 12, which is, if I remember correctly, this is the letter to the chair, and how the board, the interesting question for me, or the important question for me, would be how the board has responded to a request of this nature. And I will just put it into, not the whole letter, but just an aspect of that. For transparency purposes in the public interest, to ensure that the PIC is depoliticized and to put all stakeholders at ease about PIC investments, I've decided and now request you to do the following. Disclose all PIC transactions, listed, unlisted, and concluded in the past 3 years. The amounts on each transaction concluded, the transactional advisors, the amounts paid by PIC, disclose all the BE consortiums in those transactions, specifically state each individual or legal entity and participated in the consortium. Furnish me with a list of transactions you have concluded with parties that are prominent influential persons, and disclose details of individuals or companies who have been funded by the PIC or participated in a PIC transaction more than once in the past 3 years. How did the board respond to such an extensive request? Because I would have thought that it might be available, but it would be pretty voluminous to be doing that. Was there discussion by the board about this request? Was it tabled at the board?
Yes, Madam Commissioner, there was a discussion about the letter of the minister at the board meeting that was on the 16th of October 2017 to discuss how the board will respond to such a wide, ranging request from the minister. And I will also deal with it. It's on paragraph 16. Okay. Paragraph 58. 2 of the board members, Ms. Dudu Hlajwayo and Dr. Claudia Meaning, subsequent to receipt of the minister's letter, approached a director and chairman at ENS in their personal capacity to seek legal advice. The board charter and director's code of conduct explicitly stated that NEDs are entitled to seek professional advice, which include legal advice at the company's expense, subject to the board protocols and applicable policies.
So why would they have had to do that in their personal capacities, given that it was within their mandate as board members?
To be honest, we never got an answer to that issue. It was something which was highly debated in the meeting of the 16th of October as well. But, at the end of the day, the directors just, said they were entitled to seek their own advice in their personal capacity on matters which were, belong to the Public Investment Corporation and on issues that happened when they were board members in that capacity. So, paragraph 60. On the 16th of October 2017, I've annexed the minutes of that meeting under 13. The board met to discuss the minister's letter and decided to solicit a legal opinion whether the minister was entitled to issue directives to the PIC. One of the issues, precisely, Madam Commissioner, was the fact that the issues that the minister wanted were wide-ranging, and the board wanted to understand how they can deal with those things. ENS was appointed to provide the opinion for the PIC. These are the same lawyers who were initiators during my disciplinary hearing. These, again, Madam Commissioner, were the same lawyers whom Mrs. Hlashwayo and Mrs. Manning went to seek legal advice in their personal capacity. I must say that there was a debate in the board regarding whether there were no conflict of interest should the board appoint ENS. And the majority of the views, although there was a minority which felt that the PIC cannot appoint the same lawyers whom, the two ladies had gone to seek legal advice in their personal capacity. The majority of the board view was that because they approached a different director, the PIC is entitled to appoint another different director from the same law firm. So hence the board ultimately concluded to appoint ENS. Paragraph 61. The legal opinion was verbally presented to the board on the 19th of October 2017. I've also attached the minutes of those meetings. The written legal opinion was later emailed to me. The legal opinion confirmed that the minister was entitled to issue directives to the PIC, which is conferred by Section 6(4) of the, if this is in the public interest in line with the PIC Act 23 of 2004.
Sorry, can I just take you back a second to the question of the board appointing a legal team and the two directors? In that meeting, did the board approve or condone or take any view on the fact that Ms. Hlachwayo and Dr. Manning had been to seek in legal advice in their personal capacity? Because that would, for me, would have been a time to say, you've done that, that's fine, it's within the keeping of the rules that apply, or was there any difference of view there? What was the view of the board on the two individuals having sought legal advice, if any?
The board didn't think they are going in their personal capacity was so much an issue. The biggest issue was the fact that the PIC would now appoint the same lawyers. Yes, yeah.
Okay. Can I take you back to paragraph 55 of your statement, where you deal with the report by the minister that he had received a WhatsApp text on 13 September from a Cape Town businessman. It's clear from that text that the businessman was aware that the board would be sitting on Friday. My question to you is, are the dates of the meetings of the board made public?
The dates of the meeting of the board are not made public.
The agenda for the meetings, are they made public?
No, they are not.
The reason I'm asking you this is that if I may take the commission back to Annexure BM11, page 3 of page 3 of Annexure BM11.
Could you just read it out?
The minister is recorded to have said the following from line 12. How is it supposed to embarrass me? 1, I did not know there was a special board meeting on Friday the 15th. 2, I did not know what the agenda of that meeting was. So, is it possible the minister, who is the shareholder representative, was not aware that the board would be sitting on the 15th? He was not aware of what the agenda would be. Is it possible that someone within the PIC gave the information relating to the meeting and the agenda to the Cape Town businessman?
Yes, it is possible that someone internally could have communicated the meeting and the agenda to that businessman.
Well, it must be so. It's not that it is possible, it must be so that that happened.
Yes, Mr. Commissioner. It has happened.
Yes, you may continue.
Sorry, can we just go to the dates a second? Because you're referring to Friday the 15th, and if we go to the paragraph that we were on, it says the 16th, the minutes of the 16th. Was the 16th or the 15th the Friday?
It was,
Or is it a different month? I just want to see what relates to what.
in Annexure BM11 at page 3. The minister refers to Friday the 15th. And the text was sent on the 13th of September, that is 2 days before the meeting.
Okay, yeah, so we're in September there, thank you.
Yes, you may proceed at paragraph 62.
Okay. So on the 12th of October 2017, the following draft minutes were emailed by myself to the board. That was the board meeting held on the 28th of July, the board meeting held on the 4th of August, the special board meeting held on the 15th of September, the special board meeting held on the 29th of September, special board meeting held on the 6th of October. I must indicate, Mr. Commissioner, that the reason was that we circulated the minutes so that the members can make comments, but also because there was an elapse of time before we could also have a normal scheduled meeting where the board could then approve. So I wanted the board to also have sight of those minutes as well. So the only board member who indicated a comfort with the minutes, save for a few grammatical errors which she promised to provide, was Ms. Lindiwe Doi. I've also annexed an email in 16 where she confirmed her comfort with the minutes.
Did any of the other directors comment on any aspect of the minutes prior to the board
I
meeting?
didn't receive any comments, save from Ms. Doi.
And in the normal procedure, if you send out minutes and directors don't respond, you take it that they agree with the minutes?
Of course, Madam Commissioner, because also one of the key issues that we also was trying to introduce was the aspect of taking long to correct minutes in meetings. Therefore, when you circulate them via email, it's much quicker to correct them prior to the meeting itself. On the 17th of November 2017, there was a board meeting. This was now a normal board meeting. The minutes of the 15th of September, 29th September, 6th October, 16th October, 19th October were tabled for adoption by the board. The minutes were never considered but subsequently submitted to the board meeting of the 24th of November 2017. Instead, the board requested that the minutes be revised and be confined to matters under discussion and the endpoint resolution only. I held a different view in that all minutes of the board should be a true reflection of the discussions of the meeting. This will be noted from the transcript discussions of the meeting of the 24th of November 2017, which I have also attached as Annexure 18. How does one prove that the board discharges its fiduciary duties if minutes just captures resolutions only? Section 73, subsection 8 of the Companies Act states that I quote, any minutes of a meeting or a resolution signed by the chair of the meeting or by the chair of the next meeting is evidence of the proceedings, my own emphasis, of that meeting.
Again, just as a point of clarity, so between sort of mid-September and mid-November, being the last meeting being the 24th of November, there were 7 board meetings.
Yes, and those were just special board meetings.
All special board
All
meetings.
special board meetings from then, and then the normal ordinary meeting was the 17th of November, where I submitted the first draft, and that was when I was instructed to only stick to resolutions. And then I was instructed to submit the minutes again on the 24th of November. Paragraph 66, the Companies Act does not make any distinction between minutes of a normal meeting or an in-camera meeting. Minutes are minutes and ought to capture a true reflection of the proceedings. The alteration of the minutes of the 29th of September 2017. This happened during the meeting of the 24th of November 2017 and is annexed as PM 19. On the 24th of November 2017, minutes as originally drafted.
Just a question before you go forward. I just want to check something, which is something completely different, but since you are a company secretary, you might know. In some countries, I think the US and some states, they actually don't keep board minutes. They destroy them after that, and because mainly for lawsuits and you know, and other things. Is that how, you know, like how different are we here versus those countries? Or do you know about that?
Mr. Commissioner, I'm not clearly conversed with what the US is doing, but I can talk for South Africa. So in South Africa, issues of the board proceedings are governed by the Companies Act. And the Companies Act is very clear. In fact, in terms of records keeping, in terms of the Companies Act, minutes of a company, because remember, a company is a legal person. And as a legal person, it outlives all of us. And the reason to have minutes to be kept is for historic purposes as well. So you need, in terms of the Companies Act, you need to actually keep minutes for life, but there is a provision that now has introduced that it has to be kept for 7 years. But you know, for purposes exactly of lawsuits and other things, because remember, minutes belong to the company. And if somebody was to sue a company, even if I am no longer there, they need to be able to verify the activities of the company, whether the company secretary who took the minutes at the time is still there, whether the directors who took resolutions were still there. So in terms of the South African law, it's actually the reason why you will keep minutes, because minutes belong to a company which is a legal person. So the Companies Act is very clear to say that you need to keep those records as a historic record.
All right, great stuff. Yeah.
With your permission, Commissioner, if I may take the witness back to Annexure BM 11, at page 4 of that annexure. From line 4, the minister is recorded to have said the following, that is former Minister Gigaba, after which I received a call from a general secretary of a certain union who accused me of leading a plot to unseat the CEO in order to loot the PIC. Of course, the story came out in the newspapers the following day. Now related to that is then the allegation that I intend appointing Brian Molefe as the CEO of PIC, again, something I'm not even aware of. You know, what is your opinion on this thing of the minister receiving messages or calls from people who are outsiders asking him about the running of the PIC?
Commissioner, that was completely uncalled for. It's exactly what had transpired during the meeting when there was a report that Fedusa was trying to cancel the board meeting. And for that to be happening in an institution such as the PIC, where unions seems to be interfering in the processes of the PIC, it's definitely something that should never ever happen for an asset manager such as the PIC.
But your reflection on that, and obviously from what you've said, there's no indication who the general secretary of that union was or which the union was. But is the assumption, or can you find out whether that is part of the same call by Fedusa to cancel the meeting, and whether they in fact were the people who sent that message to the minister?
Having now heard that, I think it would have been the same, and I think we can ascertain that, Madam Commissioner. Yeah.
Yes, Mr. Commissioner, we will follow it up. You may proceed with your statement.
Can I just ask something? Do you have any difficulty, or did you have any difficulty with it being said to you, you should reflect resolutions only in the minutes?
Yes, I did, Commissioner. So if you look at, what annex is it? Under annexure 18. Where are the pages? Do you have the pages there? So if you go through annexure 18, Chair, it's just that I realized that there are no page numbers on that annexure. I'm just looking at the point where I advise the board that I cannot confine the minutes to the resolution in that annexure. Okay, so okay, so let me just maybe read the pages one by one, because the pages, apologies, Commissioner, they are not numbered. So it's the first, second, third, fourth, fifth, sixth, 7, 8, 9, 10, 11. So if you look at page 12, which is not numbered, it starts with a sentence that says, so I think we must simply say, accept the report. There, that one. If you go down, where it says Bongani, I say, but Chair, can I just differ a little bit? Because for me, what is important is that we also demonstrate that the board, in getting to a particular resolution at a committee meeting or in-camera meeting, and then I was disrupted. You need to, then I said, you need to demonstrate that the board applied its mind. And when you don't have any documentation, it is important to demonstrate that the board, for me, it will be very reckless for me. And I'm using that word to say the board discussed and then resolutions. I think I need to also protect the board in a sense that I need to demonstrate that the board, in getting to a particular resolution, it applied its mind. So that's what I said to the board.
Mr. Commissioner, if I may make a correction, it should be page 23 because this document is double-sided. You may proceed.
Okay. So,
That-
so
But of course, you don't mean by that you should record that so-and-so said this and then so-and-so then said this.
of course, Chair, I've also highlighted in my statement that you need to have a balance of, capturing the material issues. But definitely, if someone was to pierce the corporate veil at some stage, you need to really, because how do you, for board members who are not employees of an institution, how do you demonstrate if they, qualitatively, if they are taking resolutions which are in the interest of the company? You need to really ascertain how they arrived at a particular decision. Yeah, but of course you don't need to, to transcribe the discussion. Hence we have recordings which transcribe, but we also then take minutes. But in this instance, I must say, there was no recording in the first place on the 29th of September. Firstly, there was no recording that I could rely on if I had to back up. Secondly, there were no documentation that was submitted because the internal audit report was brought to a meeting and it was only given to the board members. I didn't have a copy of it. So hence I said this was not a run-of-the-mill meeting where you get a pack, like for instance, in a transaction where they are approving an investment, the investment professionals will give you a pack and they'll have their own, recommendations. It's much easier to do the minutes in that sense. But this was not a normal meeting where I could even have a pre-meeting minute prepared for it. So I went into the meeting blindly without knowing what was going to happen at that meeting. Paragraph 67. I'm on paragraph 67. On the 24th of November 2017, minutes as originally drafted were again submitted for adoption by the board. The board made changes to the minutes. A considerable number of deletions were made to the minutes of the 29th of September 2017, and it's annexed 20. During that meeting, as the board felt that these minutes portrayed a negative picture. I remember this clearly as when some board members were given instructions on how portions of the minutes should be deleted. There was one board member who felt that discussions held during the meeting be retained. I had advised the board on this aspect of comprehensive capturing of minutes and balancing between brevity and full context, which inform how certain decisions were arrived at. The board decided that the minutes of the 15th of September, 29th of September, and 16th October be adopted via round-robin resolution. This was unorthodox, as normally the board will normally correct the minutes. If there are substantial corrections, the board will still adopt the minutes, but request that the final minutes be circulated for the board to note that all the corrections have been taken into account before the chairman signs the final minutes. The round-robin resolution was prepared on the 28th of November 2017. That is Annexure 21, and circulated to the board for approval. The minutes were eventually approved via round-robin, and the round-robin only confirmed in a meeting of the 2nd of February 2018. I must say, Commissioner, this was long after the discussions of the meetings in September that these minutes were adopted by the board. It was out of the ordinary to correct the minutes by deleting the critical discussions held during the meeting. In approving draft minutes of previous meetings, the board ordinarily embarks on correcting the minutes and not deleting content which clearly and correctly reflects the true nature of the discussions in the meeting. Without this context and content, it is impossible to evaluate whether discussions taken by the board rationally flowed from the material discussions on which these discussions were based. This deprives any interested party legally entitled to have access to the minutes, the right to access the propriety and legality of such decisions, given the law of perpetuity governing a legal persona. Also, in terms of established governance practice, and as noted in the book by Rob Robson et al. On effective minute taking, which highlight that minutes need to strike a balance between being brief and comprehensively reflecting the true and accurate record of what transpired and matters that inform the decision taken by the board. One of the effects of this editing of the minutes down to the resolutions taken was that criticism by the board of the CEO's involvement in securing funding for Ms. Pretty Lou's company was effectively excised from the record, thereby sanitizing the minutes. At no point did the board highlight that the minutes did not capture the true nature of the discussions held. The board was rather concerned that the minutes reflected a negative picture. My own assessment is that I fell out of favor with the CEO, as I was the one who was responsible for drafting the minutes, which painted a negative picture about him.
Okay, if I may intervene. So from what you are saying, what you're saying is that the board was not concerned about whether what you were asked to delete was discussed at the meeting.
Correct.
They only wanted you to delete those parts of the minutes because they presented a negative picture and nothing else.
Correct.
You may proceed.
But the resolution remained the same. It was reflected correctly in the minutes. Is that correct?
Yes, correct, Chairman.
Or the conclusion of discussions on that aspect were correctly reflected and remained reflected.
The finally signed, through you, Commissioner, the finally signed minutes in terms of what was deleted, the resolution was correctly reflected. Safe to say that, of course, those discussions were excised completely from those minutes.
Sorry.
But there was no change, as it were, other than the deletion. There was no deleting this and putting something that was not there.
Not according to my knowledge.
Okay, can I ask you this question? Before the minutes of that meeting, had you ever been asked by the board to delete things from the minutes?
No.
You may proceed at paragraph 75.
Okay. Report back by Naledi Advisory Services. Mr. Franz Lekubo presented a preliminary report on the progress of the investigation to the board at the meeting held on the 17th of November 2017. He reported that he had established during this investigation that a case was opened with the SAPS to pursue a corruption case against Dr. Majila, and highlighted that he contacted SAPS to understand SAPS processes. Since the SAPS investigation was into the alleged unlawful conduct of individuals, I am not sure on what basis a PIC appointed investigator was used to interact with the SAPS and in whose interest this investigator was acting. The board agreed that a joint meeting between the Audit and Risk Committee and the ICTGC be scheduled urgently to deal with this matter. The joint meeting took place on the 17th of November 2017. I have no knowledge of the contents and or discussions held in those meetings. These joint board committee meetings were held without secretariat. I do not know who took minutes during those meetings and where the official records of the meetings are kept or what resolutions, if any, were taken. Whether proper governance protocol of ensuring that the minutes are ultimately preserved as official company record were followed is unknown. This kind of practice does not reflect good governance practice. The Companies Act is very clear and particular on how minutes, which are legal records of the company, are to be kept, as I've already alluded above.
Okay, if I may ask, were you made aware of that meeting that you referred to in paragraph 76?
Yes, of course, I was made aware of the meeting because it was the board during the meeting of the 17th which took a resolution to have that joint committee meeting. But what transpired in that joint committee meeting is unknown to me because I was not required to be in that meeting.
Were you given any reason why you were not required to be in the meeting?
No, nothing, no reasons.
Just on that same, while you may not have been, was the Secretariat asked in any way to provide secretarial services to that meeting?
Not at all, Chair. In fact, I wanted to also address that, Madam Commissioner, that even if the board was discussing something which affected me personally, the Secretariat will still have been available to assist the committee in taking minutes.
But if the board was to discuss something affecting you, would they not have been obliged to, or not obliged, shouldn't they have told you that you are the subject of the meeting, so you cannot attend the meeting to record the meeting, the minutes of the meeting?
So normally the board or the committees will tell me if there's something that is being discussed that affects me, and then they'll ask me to be excused from that meeting.
Just for the record, you mentioned ICT-GC. For the record, it's Information, Communication Technology and Governance Committee, correct?
Correct.
You may proceed at paragraph 77.
Okay. IO transaction. The sequence of events relating to this transaction and how governance processes were flouted with expediency to approve the transaction has been fully disclosed to this commission. And I will confine my statement to what had occurred before the PMC listed meeting of the 20th of December 2017. I also believe that my suspension was as a result of the leakage of the minutes and supporting documentation regarding this transaction during the beginning of 2018, which I deny to have been part of. On the 15th of December 2017, Ms. Meisha Munyela, Committee Secretary, received a telephonic request to seek approval via round robin from the Portfolio Management Committee listed investment for the listed investment team to proceed to the due diligence phase, that is PMC 1, for possible participation by PIC in IO's private share placement ahead of its planned listing on the JSC on the 21st of December 2017. During the time of the telephonic request, Ms. Munyela and I were attending a social and economic infrastructure and environmental sustainability that we call it SISFEP. It's a subcommittee of the IC. Ms. Munyela was told in an email from Mr. Victor Sien that she should leave the SISFEP meeting to urgently attend to IO transaction. This suggested that Ms. Munyela, who was taking minutes for SISFEP at the time, should leave the meeting to urgently attend to the IO transaction. Ms. Munyela prepared the request for round robin whilst in attendance at the SISFEP meeting and actioned this request at 9:52 a.m. on the 15th of December 2017. Annexure 22 is that round robin request. This she did because, of course, she was told that the closing date for the private placement was on the 15th. None of the members of the PMC responded to her email. During the course of the day on the 15th of December 2017, Ms. Munyela and Ms. Velna Low, the board secretary, were summoned to the CEO's office after he requested an agent meeting to discuss our reluctance to proceed to PMC 2, which is now request for a PMC meeting to approve the meeting before the approval for PMC 1, which had been circulated earlier. At the time, I was out of the office and I was dialed into the meeting with the CEO. The CEO was not pleased that I did not agree with a view to proceed to PMC 1 without PMC 2. Sorry, the other way around. To PMC 2 without proceeding without PMC 1. Despite the fact that PMC 1 was not yet sanctioned, the CEO wanted the resolution to waive PMC 1 because due diligence had already been done and to request for final approval to participate in IO's private placement. I knew better not to disagree with the views of the CEO, who was not only the chairman of the PMC, but also the chairman of EXCO, which would have been the forum to vary the powers of the PMC. It should be noted that PMC did not have any delegated powers to waive its own agreed investment process. Okay.
If I may intervene, you say that the CEO wanted, in that paragraph 81, you said the CEO wanted the resolution to waive PMC 1 because due diligence had already been done. Had due diligence been done? Was the CEO correct? If you know.
From my understanding, the due diligence at that time was done, but I understand it to have been a desktop deed, which was done on the 15th. Yeah.
If I may ask, is desktop due diligence enough when dealing with a transaction?
Mr. Commissioner, look, I'm not a professional, I'm not an investment professional. I believe that certain transactions would warrant a desktop DD. Certain transactions will warrant, you know, a deep dive DD, if you want to call it that. Yeah, so I don't know whether this particular transaction warranted a desktop DD or not. But I also know that in terms of the desktop DD, if it's warranted, it also saves as well as the savings for the PIC.
Okay. The second sentence of paragraph 81, you say the CEO was not pleased that I did not agree with the view to proceed to PMC2 without PMC1. Did you not agree with that view?
Yes, I did not agree with the view. Hence, I was called into the meeting when the CEO was sitting with Ms. Munyela and Ms. Lowe. I actually recall the CEO saying that, Bongani, why are we fighting? And I responded to say, I am not fighting with you, Dr. Dan. You know, so he was not pleased.
What were your reasons for not agreeing with the view to proceed to PMC2 without PMC1?
Because it would have been violation of an investment process.
Okay, you may proceed at paragraph 8.
And just for clarity on the same question, you were absolutely clear that Dr. Machila knew that a due diligence, at least a desktop due diligence, had been done as part of PMC1, even if it had not been formalized.
Yes, yes, it was. Because I believe Victor also had sent an email at that stage to say DD has now been done.
Can I just add, I think we heard from one witness that when you do a DD for a listed company, it's very different to a DD for an unlisted company, because a listed company, there's a lot about it and there's no need to visit the company, you just do desktop research, basically.
Precisely,
Yeah.
Commissioner, you're quite correct, yeah.
You may proceed at paragraph 82.
Okay. So a request for final approval of the transaction was circulated because the CEO insisted that we proceed with the transaction on the 15th. Again, no one responded to the request. Eventually, a PMC listed was requested and held on the 20th of December 2017. The signs were that PMC members were not comfortable to approve the IO transaction. It ought to be noted that I was not at the meeting, that is the 20th of December, as I was on leave, and only became aware of the issues when there were numerous media articles regarding the same. To this day, I still do not understand how the CEO could have speculated that I was responsible for leakages in the IO transaction.
Okay, did Dr. Machila tell you why he suspected that you were responsible for the leakages?
It only became apparent to me when I was handed my suspension letter, that the CEO said he was worried that there were minutes of the board and management minutes which were circulated. So it's only then after, on my suspension, on the day that I was suspended, that I realized. I'm stating this on after now, you know, having gone through what I went through. I still did not understand how he could have concluded that I was the one who leaked the management minutes.
You may proceed.
Yeah, all right. May I ask a broader question? I think you do address it somewhere probably, but let me try. In terms of the leakage of the minutes, you are the custodian of the minutes, isn't it? You are the final custodian. But do you think, how could other people sort of leak the minutes? And, you know, what is your role in terms of being the custodian of the minutes?
Commissioner, I am the custodian of the minutes, the PIC. But I'm not the only person in possession of the minutes of the PIC. Minutes of the meetings are made available, for instance, to the board as a whole, to management, to secretariat. We had at the time an S drive where all minutes were stored in that secure, in that network, in that drive. Minutes were circulated via email to the board. So there could have been other means, for minutes to have been leaked. And as a custodian, I don't have control. I only control what I can control within the secretariat. I cannot control what other people do, if we give them the minutes. Yeah.
And so meaning that they don't get collected after that and put in the minute book or whatever, people still have access to the minutes? How do they sort of get safeguarded somehow? Do they get safeguarded by any chance?
Yeah, we do try to safeguard it, but there was and still is an issue at the PIC currently in the new building where we do not have a strong room, where we would ordinarily, after the minutes have been pasted in the minute books, will be then stored. But before that happens, minutes are still circulated, either for comments, or for various reasons, before you could basically get the final minute and store it in the minute book. Yeah.
These minutes, were they sort of the final minutes, or they were just the ones which were still being corrected? Were they the final ones?
From my
The
hearing,
leaked minutes, yeah.
the leaked minutes from my hearing were the draft minutes. So these were the minutes which were not the final minutes. Yeah.
Okay.
And minutes are distributed electronically as well
Yes.
to members?
Yes. Yeah.
You may proceed at paragraph 84.
The Sagarmatha transaction. The actions of the CEO in the Sagarmatha transaction appear subject, of course, to what this commission will find not to be in line with the regular investment process. The CEO requested me to forward to investment committee members emails which were received from various political formations on the eve of the investment committee meeting to consider the Sagarmatha transaction.
Okay,
Next
if I may, it's Annexure, you were about to say Annexure BM23. Can we please go to Annexure BM23?
Can I, sorry, Mr. Monahela, before we carry on there, do you have any view as to what should happen to minutes, draft minutes, that you disseminate after they have been confirmed and you have the final minute? Are you comfortable with the fact that there are people walking around with minutes, whether in bags or in briefcases, whether they're draft or not?
First of all, I was quite concerned myself, and this is something which I told even Dr. Den at the time, to say I'm also worried that minutes, find their way to the public, domain. You see, the problem, Mr. Commissioner, is I can only control what I have control over. And one of the process for approving minutes, for instance, is to circulate draft minutes to the people that are supposed to approve the minutes. And I don't know how I can curb issues. Minutes are also emailed to the board, which, as you could tell, which was done as well. So I don't know how one could control what is beyond my control, but it's something which also worries me, and maybe perhaps one needs to think about the, things to implement to try and curb such from happening. I don't know what that would be, but one can think of, some innovative ways.
No, I'm just thinking, for instance, of stopping to send them out electronically, sending board packs rather, in hard copy, and then after approval of the minutes, those copies are collected and taken away from the board members or whoever has them. I'm just trying to think.
Yeah, that could help, Mr. Commissioner, but in the era of the technology that we live in now, one of the things that we do is we don't necessarily give the board members packs in paper. So we actually give them iPads, and packs uploaded in those iPads. And, those iPads, you know, those PICs, one can can email those things wherever. So yeah, one can think of, maybe IT people can assist, I don't know.
Yes, I know people are trying to get away from paper
Yeah,
as well.
that's actually the problem, because everything is done electronically. Yeah.
But to be clear, I'm not sure that the minutes should be top secret. You know, I think the problem with these minutes are just disputed minutes. You know, I'm not, you know, like we're speaking as if minutes must be top secret. They actually shouldn't be, you know, as far as I'm concerned. It's just that we have a problem here in the sense that those minutes were highly disputed and all that. Is that correct? Do you think I'm correct there?
Okay, I'll partly agree with you, Commissioner, to say that minutes are confidential record of a company, but I agree that the fact that these particular minutes were highly disputed, because remember, this was not the first time, even prior to my joining the PIC, it was not the first time that, you know, confidential documentation, minutes found themselves in the public domain. So, yeah, it's because precisely that these were highly disputed minutes.
Confidential, but not necessarily really top secret, that you got to go to extraordinary lengths, you know, to keep them.
Yeah, well, if for instance, you could argue that if a court orders that you disclose minutes, you have to disclose them at the end of the day. So confidential, yes, but you know, there are other means. If one really wants to know, they could have means to know. They can go to a court and say, you know, we want this thing to be disclosed. Or if there are discussions of personal nature, one could also ask, you know, through a process for those things to be disclosed. So yeah, limited
But
confidential.
not top secret, classified and all that, you know.
Okay.
I'm
They are
not sure-
confidential records
yeah.
of a company.
I'm not sure that, I mean, for my own clarification, the question of minutes of an entity like the PIC at a board level means you could be discussing, and you may well be discussing, deals that are in the pipeline, so that if you get a minute that's looking at a transaction that might be coming up, that would be of interest to other people. So the confidentiality and the integrity of the minutes, both in the recording and in the distribution, is something that should be safeguarded and as a priority. Because it's not about whether they need to be classified top secret because of other issues. It's the work of the organization,
Precisely.
which can be of interest, and therefore, for me, the question would be a method by which you ensure that board members or people involved in preparation for boards or for any other committee, it's not just boards, it's also the work of the committee, investment committee, who's taking what views, and so on, are confidential to the organization. And therefore, the security of those records becomes something that's really important for the integrity of process.
That is correct, Madam Commissioner. So, of course, minutes are confidential as well. Yeah.
Okay. I asked you to go to Annexure BM 23. You say that the CEO requested you to forward investment to investment committee members emails which were received from various political formations. Who are those political formations?
Okay. So the emails that we received, there was a letter that came from FEDUSA, signed by the General Secretary.
And can you give the names when you're doing that as well?
Okay. So it was signed by Dennis George, that is the General Secretary of FEDUSA at the time. I'm not so sure if they are still there. And then that was another one was from Kopano, Kimatla Investment Company, which I believe is an investment arm of Kosato, I'm not sure. It was signed by Stephen Tibedi, the CEO. There was a letter from PGC, which was signed by Zwelinkosi Mdlenche. There was also a email statement from the EFF.
Sorry, on the PGC, that is the investment arm of Pop Crew.
Oh, okay. Okay. And then there was also a statement from the EFF as well. And then in fact, there was also an email from Mr. Serv, that is there, email to Dr. Den with the attachment of the EFF, I think, statement.
If you look at that copy of the email from Dr. Survey, at the top there, it's COSATU letter, was that the attachment?
That was the attachment, actually, yes, of the COSATU letter. The Kopan, I think. Yeah. But those were, in essence, the emails that the CEO requested me to forward to the investment committee in an effort to try and show support for the investment in Sagarmatha.
So, are you saying that the letter, the COSATU letter, did not come directly from COSATU, but from Dr. Savi?
Yes, it was an attachment with an email from Dr. Savi.
Yes.
Can I ask a question on that? Given the issues, how much, given that this was sent to the investment committee, did the investment committee actually discuss these letters as part of its deliberations?
They never discussed those letters. They never discussed those letters. In fact, there was also a request which I deal with later in my statement about when Dr. Den requested me to schedule a telephone conference just before the investment committee said the night before to request for a telephone conference between the Sagarmatha leadership and the investment committee members. And the investment committee was not pleased with that. They were not happy that, their investment processes now will include management of companies or possibly investee companies to come and make presentation, which is not a process at the PIC.
But when you come to that, can you also refer to the attachments? I think it is in the attachments.
There is an attachment, yes.
Because of the queries members of the investment committee were making with Dr. Machila. So if we could actually have that into the record as well, because of what it would seem to me from what you're saying is that investment committees queried the Sagarmatha deal. As a consequence, letters were sent to the investment committee and the request to you to set up a meeting with Sagarmatha in relation to the investment committee's concerns.
Okay.
And would that be a standard procedure that if the investment committee has queries, that you then look at ways from external parties, including the company concerned, to come and meet directly with the investment committee? Had that occurred before?
Not to my knowledge, Madam Commissioner, it is not a normal process for the PIC when it gets into an investment. Normally what happens is the investment teams are there to do their due diligences and to make recommendations. They are the ones, the investment teams, who would have those meetings with the investment company to try and ascertain whether there's an investment case in that particular company, but not the management of that investee company coming to an IC meeting. So our investment teams are the ones that we rely the strength on to say whether there's an investment case or not to a particular investment.
This would be overriding in many ways the investment committee and the internal team working on that investment coming to the investment committee. You would then say they would normally give their views and the investment committee would have a debate with them, not with external parties.
Not with external parties. It will always be an internal process at all times. Yeah.
Okay. Was there ever any occasion before this one when you were asked by the CEO to forward emails from outsiders to members of committees of the PIC?
No, there was never such.
Okay, you may proceed. We're on paragraph 84, and you may proceed from the sentence that starts with the purpose.
Okay. The purpose of the emails was in favor of the transaction, and the purpose of their dissemination seems to have been to influence the investment committee to approve the Sagarmatha transaction. The interference by the unions and political formations in board and investment processes facilitated by the CEO is not in line with the investment and the governance process of the PIC. Interference or interventions of this nature would, I believe, shock those whose monies are supposedly being invested responsibly, cause despair and cynicism amongst those whose applications for investments are turned down for lack of political lobbying enabled by the CEO, and potentially even expose the PIC to unwarranted legal risk. These going-ons are a cause of grave concern, which hopefully this commission can address in its findings and recommendations.
Okay, if I may ask, when Dr. Machila sent you an email, or the emails, had the investment committee set, or if it had not set, when was it going to set?
Thank you. The investment committee had not set at that time when I was requested to send those emails to the IC, to the investment committee members. I think the investment committee, I'm going to have to check. The meeting was, I think, going to happen either the day after or 2 days after, because the emails were sent on the 9th of April. I can confirm that to the evidence team,
Okay,
the date of the IC meeting.
They were sent to you by Dr. Machila on the 10th of April.
Oh yes, it was the 10th of April. Sorry, I'm looking at the other one from Mr. Sev. Yeah, it was sent on the 10th of April, that in the evening just before 7. But those emails it appeared were also forwarded from those people to Dr. Machila on the 9th, some of them, yeah. But that was before the IC meeting.
You talk of facilitation by Dr. Machila. Of course, you don't know, do you, whether Dr. Machila simply received that correspondence from the various parties and simply asked you to forward it to the investment committee. If that had happened, would you find anything wrong with that?
Absolutely, Commissioner. There was everything wrong with it. I think I've already alluded to the fact that the investment process of the PIC is a closed matter in terms of first or initial investments. It's not something that, although the investment teams will engage, as I said, with the companies, such engagements are not happening at investment committee levels with the possible investee companies or companies that the PIC would intend to invest on. And Dr. Machila was quite aware, I believe, of that process, that it was just out of the ordinary, to be quite frank.
And if you had forwarded them to the transaction team, would you have a difficulty with that?
I can't tell you anything.
If you had forwarded those or that correspondence to the transaction team, the team that dealt with the transaction, would you have any difficulty with that?
It would still have been problematic because the transaction teams, to my understanding, they will engage directly with the company itself, not with political formations.
Yeah, and just to check too is that once you have these groupings, it introduces a PEP element, the PEPs and all that, and that now changes the DD completely, isn't it?
It would to a certain extent, and I'm trying to think now, because even if it introduces a PEP, in fact, everything wrong about it is actually that, because even if it introduces a PEP, at what stage would you then have a process where you then do your enhanced DD? When these kind of communications are sent directly to the IC, which is supposed to sit on an investment the following day. Because then again, you need to have time, ample time to look into those things. But this, I still say, Mr. Commissioner, was not supposed to have happened.
Sorry, as you proceed, if you can just look at your annexures, there's also a note in the annexure from Dr. Machila about the interaction with Sagarmatha around the share price of R1 and coming to a can we read that into the record as well? Because that has come up before when Dr. Survey was appearing before us about a matter that he said he did not know anything about.
Mr. Commissioner, the witness tells me that that email does not form part of the annexures to your statement.
It does, I just read it. I didn't see it anywhere else. It is there.
It's
Okay.
it's annexed.
No, you are right, Commissioner.
BM 23, ne? 20,
It's 23.
23, last page, I think.
Okay.
Or second last page. No, third last page. Third last page, I think.
Okay. Madam Commissioner, I believe you talking about the email that Dr. Machila sent to the IC committee members, which says, Dear Lindy,
Date.
the date is the 11th of April 2018. It was sent on at 10 past 1 o'clock, 10 past 1, 13:11. Dear Lindy, it reads, Dear Lindy, you can rest assured that we will not do okay. It was actually sent at 4 p.m. by Dr. Majila. It says, Dear Chairman, we have attempted to find a deal that brings closer to our bullish case, 20 Rand per share. Unfortunately, the PLS price cannot be changed. However, we negotiated a deal where we will subscribe for 3 billion worth of share made up of 50% of the shares at 39.9 Rand per share, and the other 50% at R1 per share, together with downside protection. Best regards, then. And of course, there were responses to this email. Okay? So I'm going to read the responses as I see them. There was a response as well from Ms. Lachwayo. Oh, man.
I think we only need the response from the investment committee if there is one. And Dr. Machila does not refer anywhere as to who he did the negotiations with to get to that price.
Okay. So there was a response from Dr. Manning, Claudia Manning, that says, Dear Dan, this price averages out at around 20 Rand per share, 3 times what management brought to the IC today as your base case. I'm afraid I fail to see the rationale for investing at a price 3 times higher than what your team has advised will be a good deal for our clients, i.e. 7 Rand per share. And then there was also a response from Ms. Toyi that says, Dear colleagues, I would like to express my concern that we are ignoring the sterling work that the teams have done and reported on the transaction. The different teams have also identified very clearly the risk posed by this transaction. The numbers and the facts presented to IC do not support going ahead with the transaction. My humble assessment is that this is tantamount to gambling with pension funds when we have no figures and facts to support economic merit in the transaction. And then Dr. then responded, Dear Lindy, you can rest assured that we will not do a deal that is not supported by our IC. We tried to seek comfort from IC today. It was very clear that IC was not and is still not comfortable. So far, we have not found an appropriate solution that makes the deal work. Therefore, we are not proceeding. Those are the,
Thank you, that's
okay.
fine.
So there was also, sorry, before, there was also a response by Ms. Lajwayo that says, "Dear Dr. Mkwanazi, I had serious problems with connecting to the meeting." She was calling into the meeting through the telephone this morning. And towards the end of the meeting, I got cut off and had to redial. If the decision was that management must exercise their delegated powers and notify the IC thereafter, could I also ask that management notifies GPF as a courtesy, like we normally do, especially in sensitive transactions like this one, so that the GPF trustees do not read about these transactions in the media? So those were the responses.
You may proceed at paragraph 85.
Wouldn't this be a convenient time to take the lunch agenda?
That will be fine. But
All right,
She-
it is suggested by my colleagues that we go on to paragraph 88.
thank you, Commissioner.
The CEO also requested me to arrange a meeting between the IC and Sagarmatha leadership regarding the deal on the 10th of April 2018. However, the IC refused to meet with Sagarmatha. This again is not in line with the investment process. Evidence has already been placed before this commission of inquiry that the CEO signed a sale of shares and claims agreement on behalf of the GPF with Sagarmatha on the 14th of December 2017 before the transaction was approved. This again, to my knowledge, is not in line with the investment approval process, and a decision taken on the 6th of December 2017 by the Private Equity Priority Sector and Small Medium Enterprises, that is our PEPS-FIP. It's also a subcommittee of IC, where the PIC's exit from independent news media was submitted for approval. The PEPS-FIP had made it clear in their approval that the offer to exit independent news media SA and Sekunjalo independent media should be separated from the offer to acquire a stake in Sagarmatha. The PIC's exit from independent news media should not be conditional upon the PIC's participation in the listing of Sagarmatha. I've also attached an extract of that resolution of the PEPS-FIP. Communication of the resolution of the PEPS-FIP was circulated to management as is normal practice after each meeting, including the CEO.
I just want, before my colleague asks a question, I just want to make it clear in paragraph 85. There are two things there. You were asked, you were requested by the CEO to arrange a meeting between the IC and Sagarmatha leadership. And then, however, IC refused to meet with Sagarmatha. This, again, is not in line. It's easy for one to say, or rather one to inquire, what is not in line? Is it the refusal or is it the request? Should you not rather amend there to say the request by the CEO again is not?
You are correct, Commissioner. It was the request. I'll correct that in the statement.
Yeah, just another question. I think two questions on Sagarmatha. If you recall, was this deal approved by the management? Because it seems it moved from the IC back to the delegated management process. And so the first question, was this deal approved? And it only collapsed because the JSC didn't want to list the company, just as a first question. The second one was when it was approved, did it include the INMSA as part of the transaction or not?
Okay, so this firstly was around the 10th, 11th April, and I was suspended on the 17th of April. As far as I know, the deal was not approved before my suspension, And I understand that because there were certain compliance aspects that were not complied with the JSC. I don't know whether it was approved after my suspension, but before my suspension, it was not approved. But I can check for the commission.
Doesn't it follow that if it eventually went to the JSE, it would have been approved?
I think I'm gonna.
If you know.
I'm gonna base my response on the email from Dr. Majila, where he said, if the deal is not supported, they are not gonna approve. So, I think based on that, I don't think they would have, because in the first place, the deal fell within the delegation of management. So, maybe it was because of the risk element to it that the management decided to go to IC, and by virtue of the fact that the IC did not support the transaction, I don't think it would have been logical for management to then approve something which is, in the first place, they brought to the attention of their principals, and it was not supported by their principals.
I think we can double check that, but if I can recall, one witness said that if it was not of the JSC, this could have gone through, but we can double check that, mainly because also there were some put options that were worked out between Dr. Den and the other party, the sponsor. But yeah, but it's something which we need to double check whether, if it was not of the JSC, could this 3 billion rand actually have been spent?
Okay, Commissioner, I will double check that.
If I may, the evidence placed before this commission by employees of the PIC is that Dr. Dan Majila signed the irrevocable subscription form relating to the Sagarmatha transaction on the 14th of December 2017. Are you aware of that?
The IU, isn't it? It's not
Yes, it's
Sagarmatha.
IU.
It's not Sagarmatha.
No, I'm asking about IO.
Oh, okay. We were talking about Sagarmatha here, but you know.
No, there is a follow-up question
Oh,
to
okay.
the question that I've just asked.
I get you.
Yes, I'm aware. I've heard about that in the evidence before this commission.
That would mean, according to your statement at paragraph 86, that Dr. Majila also signed the sale of shares and claims agreement relating to the Sagarmatha on the same day.
Correct.
Do you know if any due diligence was done before Dr. Den signed the sale of shares and claims agreement relating to Sagarmatha?
I don't know if there was any due diligence that was done prior to his signing the sale of shares agreement.
I think given the question, let's just look at your paragraph 86 and ask you just to, not necessarily now, but just to reconfirm that in fact that evidence has, that the inquiry that the sale of shares and claims agreement on behalf of the GPF with Sagarmatha was signed by the CEO on the 14th of December, long before the transaction was approved. That is correct?
That is correct.
That's correct. And that's
That's correct.
Sagarmatha we're talking about. We're
That
not
is
talking about
Sagarmatha,
Higher.
Madam Chair,
Yeah.
yes.
Thank you.
Mr. Commissioner, I confirm I have a copy of the agreement in my possession, and we will place it before the commission. It was signed on the 14th
Of December
of
26.
December by Dr. Denondo, and on the 13th by a representative of Sagarmatha.
We'll be happy if you hand up copies of that agreement.
I will do so, Mr. Commissioner.
Thank you.
Then the follow-up question is this, my second question. Those transactions were linked, so the independent media issues versus Sagarmatha. Do you know what happened to that issue, Mr. Monahela or Ms. Matevola? There was always a link that the PIC will invest in Sagarmatha, and then there will be a takeout or buyout of the independent media by Dr. Seve's company.
Mr. Commissioner, I don't know if I understand the question, but the agreement that we have is not what it purports to be. It is referred to as the sale of shares and claims agreement, but there was no sale of shares. Can I just try to find whether I have it with me, Mr. Commissioner?
It's fine, we can talk about it, and then after the break and all that, yeah, there's no issue.
Yes, I think we will adjourn now for lunch until 2:15.